Before we begin, it's critical to understand this. I am not a lawyer, and this presentation is not legal advice. The information and scenarios we are about to discuss are for educational and informational purposes only. Every legal situation is unique, and laws vary significantly by state. If you are facing a specific legal issue, your first and most important step should always be to consult with a qualified attorney licensed to practice in your jurisdiction. This video is designed to be a starting point, a guide to help you recognize when that call might be necessary. You're driving home from work. It's a Tuesday. The light turns yellow, you slow down, and then bam, a jolt from behind. It's not a huge crash, more of a solid, definite thud. You and the other driver pull over. You both get out. He's young, apologetic, says he was looking at his GPS for a second. Your neck is a little sore, and there's a decent dent in your bumper, but the car is drivable. He looks at you and says the one thing that sounds so reasonable, so easy. Hey, my insurance will just go up. How about we handle this without them? I can just pay you for the damage. Let's not get lawyers and all that stuff involved. And in that moment, you're faced with a decision that could either save you a minor headache or cost you tens of thousands of dollars and months of agonizing stress. What do? Most Americans in that exact situation make the wrong choice. They agree, they shake hands, and they have no idea they just walked into a legal minefield completely unarmed. That's because we're taught to see lawyers as a last resort, a nuclear option for messy divorces, huge corporate lawsuits, or serious criminal charges. We think of hiring an attorney as expensive, confrontational, and complicated. And it can be. But what no one tells you is that not hiring an attorney at the right moment is almost always more expensive, more confrontational, and infinitely more complicated down the road. This is your guide to those moments. We are going to arm you with a critical skill: the ability to spot the legal red flags in your everyday life before they explode into full-blown crises. We're going to cut through the jargon and the fear and give you a clear, practical roadmap for when you, an average American, actually need to lawyer up. This isn't just about car accidents. We're talking about that freelance contract you're about to sign, the dispute with your landlord over a security deposit issue, the vague non-compete agreement in your new job offer, the process of writing a will to protect your family. These are the moments where a single 1-hour consultation with a lawyer can be the highest return investment you ever make. By the end of this presentation, you will have a mental checklist that will empower you to protect your money, your family, and your peace of mind. So let's go back to that car crash. That seemingly simple fender bender is the perfect case study for why the "let's just handle this ourselves" approach is one of the most dangerous financial mistakes you can make. Let's break it down. First, the injury. You said your neck was a little sore. Adrenaline is a powerful painkiller. It can mask serious injuries for hours, even days. What feels like a minor tweak could be a soft tissue injury, a herniated disc, or worse, that won't fully manifest until you wake up 2 days later unable to turn your head. By then, you've already told the other driver and potentially their insurance company, "I'm fine." That statement, made in good faith just minutes after the impact, can be used against you as an admission that the accident didn't cause your injuries. You've unknowingly undermined your own potential claim. A personal injury attorney knows this. Their first piece of advice would be, get medically evaluated immediately, even if you feel fine. This creates a medical record that officially links any discovered injuries directly to the time and date of the accident. Without that link, an insurance company can and will argue that your injury could have happened anytime. Maybe you heard it at the gym. Maybe you slept on it wrong. Their job is to create doubt, and you just handed them the tools to do it. Second, let's talk about the other driver's insurance company. You might think, okay, I'll just call his insurance and they'll take care of it. You have to understand who you're calling. The insurance adjuster who calls you back might sound like the nicest, most helpful person in the world. They'll be sympathetic. They'll say things like, "We just want to make this right," or "Let's get this settled quickly so you can move on with your life." This is a tactic. The adjuster's primary, legally mandated job is not to help you. It is to protect their company's financial interests. That means their goal is to pay you the absolute minimum amount possible, or ideally nothing at all. They are highly trained negotiators armed with software, statistics, and a deep understanding of legal procedure. You are an amateur walking into a professional's arena. They will often ask to record your statement. This is not for your benefit. They are hoping you'll say something innocent that they can later twist to minimize your claim. You might say, "Well, the light had just turned yellow." and they'll use that to argue you share part of the blame for the accident, a concept called comparative negligence, which can drastically reduce your payout in many states. You might say, "I'm just a little sore," and they'll lock that in as your official statement on your physical condition. A lawyer acts as your shield. Once you have legal representation, that adjuster is no longer allowed to speak to you directly. All communication must go through your attorney. The entire power dynamic shifts. The lawyer knows their tactics, speaks their language, and understands the true value of your claim, which isn't just the car repair. It includes medical bills, present and future, lost wages if you have to miss work, and compensation for pain and suffering. These are things you would likely never even think to calculate, but they are legitimate damages you are entitled to. Third, the quick cash offer. Let's say the other driver's insurance company calls you a week after the accident. You've been to the doctor, you have whiplash, and you've missed a few days of work. The adjuster says, "Look, we can see you've got about $1,000 in medical bills and you lost $500 in wages. We'll send you a check for $3,000 right now. You just have to sign this release form, and this whole thing will be over." That sounds tempting. $3,000 right now. No more hassle. But that release form is a legally binding contract. Once you sign it, you are forever waiving your right to any further compensation for this accident. What happens if 6 months from now, your whiplash requires extensive physical therapy? What if it develops into a chronic pain issue that affects your ability to work or enjoy your life? It doesn't matter. You signed the release. The case is closed. You can't go back for more money. An attorney would never let you sign that. They would evaluate the full, long-term potential of your injuries and negotiate a settlement that actually covers you, not just for the immediate inconvenience, but for the foreseeable future. That $3,000 offer could easily be a $30,000 reality, but you'd never know it without professional guidance. So the red flag in this scenario isn't the crash itself. It's the moment anyone, the other driver or their insurance company, suggests handling a situation involving physical injury and property damage without formal documentation and professional oversight. The moment you hear, "Let's keep the insurance out of this," or "Let's just settle this quickly," that's your signal. That is the moment you stop talking, you document everything, you get a medical checkup, and you make a call to a personal injury attorney for a consultation. Most of them work on contingency, meaning they only get paid if you get paid. So the initial call costs you nothing, but making that call could be the difference between a fair settlement and a devastating financial loss. A fender bender is never just a fender bender. It's your first test. Your next test happens when you least expect it, not on the road but in the one place you feel you've earned your security, your job. Imagine you've worked at the same company for 12 years. Let's call you David. You're not just an employee. You're part of the furniture. You've mentored junior staff, stayed late to hit deadlines, and poured your professional life into this place. You're loyal. You're reliable. And one Tuesday morning, your manager calls you into an unscheduled meeting with someone from human resources you've never seen before. The room is cold. The smiles are fake. And then they say the words, "David, we've decided to restructure the department. Your position is being eliminated." Feels like a punch to the gut. Your mind is racing. Your mortgage. Your kid's college fund. The sheer humiliation of being walked out with a box of your personal belongings. You're in shock, a state of emotional freefall. And in that exact moment of maximum vulnerability, the HR person slides a thick manila folder across the table. "This is your severance agreement," she says, with a voice that's trying to sound sympathetic but is pure corporate monotone. "It's a standard agreement. We're offering you 4 weeks of pay, plus your accrued vacation time. It's a very generous offer. Just sign here, here, and here, and we can process your final check." Your brain is screaming. For weeks? For 12 years of my life? But another part of you, the part that's drowning in shame and just wants this nightmare to be over, is saying, "Asterisk, just sign it. Take the money and get out of here. Don't make a scene." Asterisk. This is the moment. This is the tripwire. This is the exact point where 99% of people make a catastrophic, life-altering mistake. Because that standard agreement is not your friend. It is not a gift. It is a weapon drafted by the company's high-priced lawyers for one purpose and one purpose only: to protect the company from you. Let's dissect this weapon. That generous offer of 4 weeks' pay isn't a gift. It's a price. It's the price they are paying you to buy your silence and your rights. Forever. Buried deep in that dense, unreadable legal jargon is a sentence that will change your life. It's called a general release of all claims. Sounds harmless. It is legal dynamite. By signing that document, you are not just agreeing to the terms of your departure. You are legally stating under penalty of perjury that this company has never, ever done anything wrong to you. Ever. Think about that. Did your boss pass you over for a promotion last year in favor of a younger, less qualified colleague? By signing, you agree it was fair. Did you work hundreds of hours of unpaid overtime that you were legally entitled to? By signing, you agree you were paid for every minute. Were you subjected to a hostile work environment, inappropriate comments, or subtle discrimination? By signing, you agree it never happened. You are retroactively erasing every potential legal claim you might have had, from age discrimination to wage theft to wrongful termination. You are handing the company a get-out-of-jail-free card for your entire 12-year history, and they are buying it from you for the low price of 4 weeks' pay. But it gets worse. The document will almost certainly contain a non-disparagement clause. This means you can never say anything negative about the company, its management, or its products to anyone ever again. Not in a job interview, not on social media, not even to your spouse over dinner. If you do, they can sue you and claw back every penny of that severance. But here's the kicker. That clause is almost always one-sided. There's nothing stopping your old manager from telling a prospective employer that you were difficult or not a team player, effectively poisoning the well for your future career. You've been gagged, but they haven't. And then there's the big one, the non-compete clause. They might try to tell you it's standard procedure. It is not. It can be a career death sentence. Buried in the fine print could be a clause that prevents you from working for any competitor, in any capacity, within a 50-mile radius for the next 2 years. In today's economy, what does that even mean? If you work in tech, does that mean you can't work for any other tech company? If you're in sales, does it bar you from the entire industry that represents your life's work? They are paying you 4 weeks of salary to potentially take you out of the workforce for 104 weeks. The math is insane. Now let's rewind. You're in that cold room. The pen is in your hand. But instead of signing, you do the one thing they don't want you to do. You take a deep breath, look the HR person in the eye and say, "Thank you. I'm going to have my attorney review this." The change in the room is immediate. The fake smiles vanish. The pressure tactics begin. Well, this offer is only good for 24 hours. That's a lie. Federal law, specifically the Older Workers Benefit Protection Act, gives workers over 40 at least 21 days to consider a severance agreement. They are counting on you not knowing that. You walk out of that building not with a paltry check, but with the most powerful tool you have, the document itself. You call an employment lawyer. Most, like personal injury lawyers, work on contingency or offer a free or low-cost initial consultation to review the agreement. The lawyer reads it and immediately sees the landmines. But then, they start asking questions the company never wanted you to be asked. "David, tell me what happened. You're 55. Who did they hire to replace you? Oh, a 28-year-old? And they're paying him less? Interesting." Or, "David, you filed a complaint with HR about your manager 6 months ago, didn't you? And now you're being restructured?" That sounds a lot like a legal retaliation. Suddenly, the entire dynamic shifts. You are no longer the victim. You are a threat. Your lawyer sends a letter to the company. The 4-week offer is rejected. The negotiations begin. That standard non-compete clause? It magically vanishes. The one-sided non-disparagement clause suddenly becomes mutual. And that 4 weeks of pay? It becomes 6 months. Or a year. Or a lump sum settlement that takes into account the potential age discrimination lawsuit they are now terrified you're going to file. The difference isn't just a few $1,000s. It's the difference between a financial crisis and a stable bridge to your next job. It's the difference between being silenced and preserving your reputation. It's the difference between being a victim of a corporate system and forcing that system to treat you with the dignity and respect you earned over 12 years. The rule is simple and it is absolute. The moment you are fired, laid off, or pressured to resign, and someone puts a piece of paper in front of you to sign, you are in a legal battle. You may not think of it that way. You may be too emotional to see it. But the company sees it that way. Their lawyers have prepared for this battle for months. Handing you that severance agreement is their opening salvo. Do not walk into that fight alone. But the workplace isn't the only place where a single signature can detonate your life. The most dangerous legal documents aren't always pushed across a boardroom table by a stranger in a suit. Sometimes they're handed to you across the kitchen table by the people you're supposed to trust the most. Let me paint you a picture. It's a love story. Two people, let's call them Sarah and David, are deeply in love. They're planning their future, picking out venues, tasting cakes. David comes from a family with a successful multi-generational construction business. It's not a mega corporation, but it's substantial. One evening over dinner, David brings something up. He looks uncomfortable. "My dad," he says. He's insisting we sign a prenuptial agreement. "It's just a formality, to protect the business for my siblings if, anything ever happens." Sarah's heart sinks. A prenup? Feels so transactional, so cynical. It feels like his family doesn't trust her, like they think she's a gold digger. David reassures her. "It's not about us, honey, I promise. It's just business. Look, my family's lawyer already drafted it. It's super standard. We can just sign it and get it over with. We don't need to make a big deal and hire more lawyers. It'll just get expensive and awkward." And right there, in that moment, is the tripwire. The phrase "my family's lawyer" or "our lawyer," when it's really their lawyer. Sarah, wanting to be the cool, understanding fiancée, wanting to prove she isn't after his money, agrees. She reads the document. It's full of dense legal language she doesn't fully understand, but it seems to mostly talk about the family business, which she doesn't care about anyway. So she signs it. They get married. They have a beautiful life. They have 2 kids. She quits her career to raise them. She supports David as he works his way up to run the company. They build a life together for 15 years. And then it falls apart. The divorce is messy and painful. Sarah finally takes that 15-year-old document to a lawyer of her own. The lawyer reads it and her face goes pale. She looks at Sarah and says, "This is one of the most brutal one-sided prenups I have ever seen." It turned out the standard document didn't just protect the family business. It waived Sarah's right to any spousal support ever. It defined marital property in such a narrow way that the multi-million-dollar home they lived in, which was technically bought through a trust from the business, wasn't considered a shared asset. It waived her rights to his retirement accounts. After 15 years of being a dedicated partner and mother, she was legally entitled to walk away with almost nothing. The lawyer David's family hired did his job perfectly. He protected his client, the family business, and David. He had zero obligation to be fair to Sarah. This is the #1 trap in family and relationship law. Assuming the other person's lawyer is neutral. A lawyer's duty is to advocate fiercely for their client's interests, and their client's interests alone. The moment a document with legal weight enters a personal relationship, you are no longer just partners or family. You are 2 distinct legal entities with potentially opposing interests. Signing something without your own independent legal counsel is like walking into a sword fight armed with a butter knife. You might trust the other person completely, but you're not negotiating with them. You're negotiating with their lawyer, through a document designed to give them every possible advantage. This poison spreads far beyond prenups. Think about co-signing a loan for a family member. Your brother wants to buy his first car, but his credit is shot. The bank says he needs a co-signer. You love your brother, you want to help him. You go to the bank, you sign the paper. Feels like a simple act of support. But what you have legally done is tell the bank, if he doesn't pay, you can treat me as if I took out this loan myself. Come after my savings, garnish my wages, destroy my credit score. I am 100% on the hook. The bank isn't going to chase your brother for months if they know you're an easier target. They will come for you. A 5-minute consultation with a lawyer would have revealed 5 other ways to help your brother, without putting your entire financial future on the line. Or what about lending money to family? Your daughter and her husband are trying to buy a house, and they're just a little short on the down payment. You give them $20,000. You all agree it's a loan, they'll pay you back once they're settled. There's no paperwork, just a hug and a thank you. You trust them. But in the eyes of the law, without a signed promissory note clearly outlining the loan amount, interest rate, and repayment schedule, that $20,000 was a gift. Period. If they later decide they can't or won't pay you back, you have almost zero legal recourse. You can't prove it wasn't a gift. You've just learned a $20,000 lesson about trust. It even happens with the home you live in. You own your house outright. You get remarried, and in a gesture of love and commitment, you add your new spouse to the deed. What could go wrong? Well, you've just legally gifted them half of your home's value. If you divorce 5 years later, they are likely walking away with half of your single biggest asset, even if they never contributed a penny to it. Or worse, what if your new spouse has a secret gambling debt? Or gets into a catastrophic car accident and is sued? Because their name is on the deed, creditors can now put a lien on your house to satisfy their debt. Your home, your sanctuary, is now exposed because of a signature made out of love, without legal advice. In every one of these scenarios, the pressure isn't coming from a shark in a pinstripe suit. It's emotional pressure. Don't you trust me? Why do you have to make things so complicated? We're family, we don't need lawyers. That's the siren song that leads you onto the rocks. The moment you hear those words, it should be a blaring alarm bell in your head telling you that you need your own lawyer. Immediately. A lawyer isn't there to blow up the deal or to sow distrust. They are there to be your advocate, your translator, and your shield. They are the one person in the room paid to think about the worst-case scenario so you don't have to live through it. Now let's move out of the kitchen and into the office because the exact same power dynamics are at play, just dressed up in corporate jargon. You just got the call. You landed the dream job. The offer is fantastic, the team seems great, you are ecstatic. They send you the official offer letter, and with it, a digital stack of documents to sign. An employment agreement, a non-disclosure agreement, a non-compete clause, an arbitration agreement. It's a flurry of excitement. You scroll, you click, I agree, you initial here, you sign there. You're just thinking about your start date and what your new desk will look like. You're not thinking about the fact that you just signed away some of your most fundamental rights. That non-compete agreement? You might think it's just standard procedure. But depending on how it's written, you may have just agreed that if you ever leave this company, you can't work for a competitor, or even start your own business, in the same industry in the same state for the next 2 years. You've essentially given your employer the power to sideline your entire career if things don't work out. And that arbitration agreement is even more insidious. It sounds harmless, like a way to resolve disputes efficiently. What it actually means is that you are waiving your constitutional right to sue your employer in a public court of law. If they wrongfully fire you, if they discriminate against you, if they don't pay you the overtime you're owed, you can't take them to court. You can't have a jury of your peers hear your case. Instead, you have to go into a private, binding arbitration process. And guess who pays the arbitrator? Often it's the company. Guess who has a long-term business relationship with the arbitration firms? The company. It is a system heavily skewed in the employer's favor. And you signed up for it on your first day because you were too excited to read the fine print. You think you're signing paperwork to start a job. But what you're really doing is signing the rulebook that governs how that job can end. And that rulebook was written entirely by the company's lawyers to protect the company's interests. The most critical negotiation of your career isn't for a 5% salary bump. It's for the terms that dictate your freedom and your rights when the relationship is over. And this is where the game is truly played. Let's talk about the moment most people feel the most vulnerable in their professional lives. Getting laid off. The meeting is always cold and impersonal. Someone from HR you've never met is in the room. Your boss, who was your friend yesterday, can't make eye contact. They slide a thick folder across the table. It's your severance agreement. They'll tell you it's a standard package. They'll say it's generous. They'll give you a week, maybe 2, to sign it. And that pressure, that feeling of shock and humiliation, is a powerful tool they use against you. They are counting on you to be too emotional, too scared, and too financially desperate to do the one thing you absolutely must do. Take that packet, say thank you for your time, I will review this, and walk directly to an employment lawyer's office. Because that standard package is a weapon. It's a legal document designed with one purpose: to buy your silence and your rights for the lowest possible price. Inside, you'll find a clause called a general release of all claims. Sounds like boilerplate legal jargon. What it means is that in exchange for a few weeks of pay, you are forever surrendering your right to sue the company for anything. For everything. Did your boss discriminate against you because of your age? You can't sue. Were you denied a promotion after you reported sexual harassment? You can't sue. Did the company illegally underpay you for years of overtime? Once you sign, you can never get that money back. You are signing away your past, present, and future legal rights, often for pennies on the dollar of what they might actually be worth. Then you'll find the non-disparagement clause. This is the muzzle. It says you can't say anything negative about the company, its employees, or its products ever again to anyone. Not in a future job interview, not on an anonymous Glassdoor review, not even to your spouse over dinner. If you do, they can sue you and demand you pay back the entire severance. It's a lifetime gag order. They get to control the narrative of why you left while you are legally silenced. And the most sinister of all? The non-compete and non-solicitation clauses. They might offer you 2 months of severance pay but bury a clause that says you can't work for a competitor in your own industry in the entire country for 2 years. They are effectively paying you to end your own career. An employment lawyer sees these clauses for what they are: an opening bid in a negotiation you didn't even know you were in. They know which clauses are legally enforceable in your state and which are pure intimidation. They know how to push back, to strike out the non-compete, to limit the non-disparagement clause, to triple the severance pay by pointing out the potential age discrimination claim the company is so desperate to make go away. Paying a lawyer a few $1,000s to review that agreement could be the highest return investment you ever make. It could be the difference between a few weeks of pay and a settlement that gives you a year to find the right job. It could be the difference between being muzzled and being free. But what if you don't even get an offer? What if you're just fired? You're escorted out of the building with your belongings in a cardboard box. You feel it was deeply unfair. But was it illegal? This is one of the most misunderstood concepts in American life: wrongful termination. We hear about it on TV, but most of us don't know what it actually means. The vast majority of American workers are employed at will. And that phrase is terrifying. It means your employer can fire you for a good reason, a bad reason, or no reason at all. Your boss doesn't like the color of your shirt? You can be fired. They think you're a fan of a rival sports team? You can be fired. They just don't like your personality? Gone. It's brutal, and it feels fundamentally unjust. But at will has a massive exception. It's a line in the sand. They can fire you for any reason as long as it's not an illegal reason. And what's an illegal reason? It boils down to 2 main categories: discrimination and retaliation. Discrimination means they fired you because you are a member of a protected class. This includes your race, religion, gender, national origin, age if you're over 40, and disability. This is where the company's story starts to matter. No company is foolish enough to say, "We're firing you because you're pregnant." Instead, a pattern emerges. A woman has a stellar performance record for 5 years. She announces her pregnancy. 2 months later, she's suddenly put on a performance improvement plan for vague reasons. Her projects are given to a junior male colleague. A month after that, she's fired for not meeting expectations. This is the pattern a lawyer is trained to see. They'll gather the evidence, the past performance reviews, the emails, the timing of it all. They'll build a case that the poor performance was a pretext, a manufactured excuse to hide the real illegal reason for your termination. The same goes for age. An employee is in their late 50s, a top performer for decades, one of the highest paid people on the team. The company announces a restructuring. He and 3 other employees over 55 are laid off, while their responsibilities are absorbed by younger, cheaper employees. The company calls it a reduction in force. A lawyer calls it a potential age discrimination lawsuit. The second illegal reason is even more common: retaliation. This happens when an employee engages in a legally protected activity, and the employer punishes them for it. What's a protected activity? Complaining about discrimination or harassment is the big one. You go to HR and report that your manager is making unwanted advances. You do exactly what you're supposed to do. A month later, you're fired for insubordination or not being a team player. That's not a coincidence. That's retaliation. Another huge one is whistleblowing. You report an unsafe working condition to OSHA. You report financial fraud to the SEC. You refuse your boss's order to lie to a client or break the law. These are all protected activities. If you get fired shortly after doing any of them, you don't just have a hunch, you have the foundation of a wrongful termination case. The law is designed to protect people who speak up. A lawyer's job is to enforce that protection. And this brings us to the most dangerous misconception in the corporate world: the role of human resources. We are conditioned to believe that HR is a neutral party, a safe place to go with our problems. This is a catastrophic mistake. HR's primary function, their legal and fiduciary duty, is to protect the company. They are not your friend. They are not your therapist. They are not your advocate. They are the company's first line of defense against you. When you go to HR to report harassment, their first thought isn't, "How can we help this employee?" It's, "How can we mitigate the company's legal risk?" They will investigate, yes, but their investigation is designed to find the path of least liability for the corporation. Sometimes that aligns with helping you. Often it does not. If you are documenting a serious issue like harassment or discrimination, you should assume that every email you send to HR will one day be read by the company's lawyers to be used against you. They are building a file on you from the moment you walk in their door. That is why, if the situation is serious, you need someone building a file for you. A lawyer is the only person in this entire scenario whose sole, undivided loyalty is to you and your best interests. They can advise you on how to phrase your complaints to HR to create the strongest possible record. They can tell you when HR's response is inadequate or illegal. And they can tell you when it's time to stop talking to HR and let your lawyer do the talking for you. The power dynamic between an individual employee and a corporation is one of the most lopsided in our society. The company has a team of lawyers on retainer. Yep, HR. Leveling that playing field is the first and most important step to protecting your career and your rights. So when exactly does that playing field need leveling? Let's start with the big one, the one that blindsides countless Americans every year. Getting fired. You walk in one morning and by noon you're carrying your life in a cardboard box. The first thing you have to understand is a concept called at-will employment. In almost every state, this is the default. It means your employer can fire you for any reason, because they don't like your shoes, because you cheer for a rival sports team because it's a Tuesday, or for no reason at all. Feels unfair, and it often is. But being fired unfairly isn't the same as being fired illegally. The line is crossed when the real reason for your termination is discriminatory or retaliatory. The law protects certain classes of people. You cannot be legally fired because of your race, your gender, your religion, your age, your national origin, or a disability. You also can't be fired for becoming pregnant. Imagine a woman named Jessica. For 5 years, she's been a star performer at her marketing firm. She consistently exceeds her sales targets. Her reviews are glowing. She's on track for a promotion to senior manager. Then she tells her boss she's pregnant. The congratulations seem genuine. But then things change. Suddenly, her work is being micromanaged. She's left out of important meetings. Her boss starts making comments about her priorities changing and whether she'll have the same level of commitment after the baby arrives. 2 months later, there's a department restructuring. Jessica, despite her stellar record, is let go. They tell her it's a purely financial decision, that her position has been eliminated. But a week later, she sees a job posting for a role that is identical to hers, just with a different title. This is the moment the alarm bells should be screaming. The company has a perfectly plausible, legal-sounding reason on paper. But the timing, the comments, the sudden shift in treatment, it all tells a different story. This is not just an unfair situation. It's potentially illegal pregnancy discrimination. Without a lawyer, Jessica is facing a corporate wall. She can file a complaint with the Equal Employment Opportunity Commission, the EOC, but that process can be slow and overwhelming. A lawyer, on the other hand, can immediately send a letter to the company demanding they preserve all records, emails, performance reviews, internal chats. They know exactly what evidence to look for, how to depose witnesses, and how to build a case that peels back the company's excuse to reveal the discriminatory intent underneath. They can negotiate a severance package that reflects the damages she's suffered, or, if necessary, take the company to court. For Jessica, hiring a lawyer isn't about revenge. It's about justice and holding a company accountable for breaking the law. The same principle applies if you're fired in retaliation. Let's say you report your supervisor for sexual harassment, or you blow the whistle on the company for committing financial fraud, or you file a workers' compensation claim after getting injured on the job. These are all legally protected activities. If your company fires you shortly after you do one of these things, that's a massive red flag for retaliation. The company will almost never admit it. They'll invent a performance issue or claim your job was eliminated. An employment lawyer's job is to connect the dots and prove that their stated reason is just a pretext, a cover story for illegal retaliation. But sometimes the problem isn't a single event like being fired. Sometimes it's a slow, grinding poison that makes your life a living hell every single day. This is the territory of a hostile work environment. Again, let's be clear. A boss who is just a jerk is not illegal. A workplace that is stressful is not illegal. For a situation to become a legally hostile work environment, the conduct has to be both severe or pervasive, and it has to be based on your membership in a protected class. Think about David, a 58-year-old software engineer, highly experienced and respected in his field. A new 30-year-old manager takes over his department. The manager starts making constant jokes about David being a dinosaur. and asking when he's going to ride off into the sunset. In meetings, he'll say things like, "Let's get a fresh perspective on this, someone who isn't stuck in the 90s. He gives all the exciting new projects to younger employees, leaving David with tedious maintenance tasks. At first, David tries to laugh it off. Then he tries to ignore it. But it's relentless. It happens every day in front of his colleagues. He starts to dread going to work. His confidence plummets. His anxiety skyrockets. He speaks to HR, and they tell him the manager just has a different style, and that David should try to be less sensitive. What HR is doing is trying to make the problem go away with the least amount of risk to the company. What they are ignoring is a classic case of age-based harassment creating a hostile work environment. It's pervasive, it's happening constantly, and it's based on his age, a protected class. David doesn't have to put up with it. A lawyer would first advise him on how to document everything, every comment, every demeaning task assignment, every dismissive interaction with HR. Then, they would likely draft a formal letter to the company's legal department, putting them on notice that their failure to address the illegal harassment will result in legal action. Suddenly, the company isn't dealing with an employee they can brush off as too sensitive. They're dealing with a legal professional who understands the Age Discrimination in Employment Act inside and out, and who is prepared to go to court. The power dynamic shifts instantly. Finally, let's talk about your paycheck. This is one of the most common areas where employers quietly break the law, because they know most employees won't notice or won't know their rights. It's called wage theft, and it takes many forms. Are you being asked to work through your lunch break without pay? Are you expected to answer emails and finish up reports at home off the clock? Are you a salaried manager who spends 90% of your time doing the same work as the hourly employees you supervise? This could be a case of misclassification, a trick companies use to avoid paying you overtime. In some states, are your tips being pooled and shared with managers or kitchen staff who don't directly serve customers? These are all potentially illegal. Individually, it might seem like a small amount, 15 minutes of unpaid work here, $100 there. But it adds up. Over the course of a year, it can be thousands of dollars that were legally earned by you and illegally kept by your employer. A wage and hour attorney specializes in this. They can often file claims not just for you, but for a whole group of employees who have been affected, turning it into a class action lawsuit. They can conduct an audit of the company's pay records and force them to pay back wages, often with penalties. This isn't just about getting your money back. It's about enforcing the fundamental principle that you must be paid for the work that you do. In all of these scenarios, wrongful termination, harassment, wage theft, the most dangerous misconception is that HR is there to help you. HR's job is to protect the company. They are not your friend. They are not your advocate. They are risk management for the corporation. When you go to them with a serious complaint, their first thought is not, "How can we help this employee?" It's, "How can we minimize the company's legal and financial exposure?" That is why, when the stakes are high, you need your own advocate. You need someone whose only job is to protect your interests. And don't let the fear of cost stop you. Nearly every reputable employment lawyer in the country offers a free initial consultation. You can tell them your story, and they will tell you whether or not you have a case with no obligation. Furthermore, most of these lawyers work on a contingency fee basis. That means they don't get paid unless you get paid. They take a percentage of the settlement or the court award. This system was designed specifically to level that playing field, to allow people like Jessica, David, and you to take on a massive corporation without having to risk your own money. It means your lawyer is just as invested in winning as you are. Because in these situations, the most expensive mistake you can make is doing nothing at all. But what if the damage isn't to your career, but to your body? What happens when a simple accident becomes a life-altering event? That's where the stakes get even higher. Imagine a crisp Tuesday morning. You're stopped at a red light, sipping your coffee, mentally running through your to-do list for the day. Suddenly, a jarring slam from behind. Your head whips back, then forward. Your coffee goes flying. You're dazed. The driver behind you is texting, didn't see the light, and plowed right into your bumper. You both get out. He's incredibly apologetic. You exchange insurance information. Your neck is a little sore, but your adrenaline is pumping. You think, "I'm okay. It's just a fender bender." You tell the other driver and the police officer who arrives, "Yeah, I'm fine, just a little shaken up." That single sentence, "I'm fine," can become the most expensive one you ever utter. Because the next morning you wake up and you can't turn your head. The soreness has blossomed into a searing pain that shoots down your spine. A trip to the doctor reveals you have a serious whiplash injury, maybe even a herniated disc. You're going to need physical therapy for months, maybe even surgery. You can't work. The medical bills start piling up. And then the phone rings. It's a friendly, sympathetic adjuster from the other driver's insurance company. They heard you told the officer you were fine at the scene. They're so sorry this happened and they want to make it right. They offer you $5,000 to settle everything right here, right now. Just sign on the dotted line, and this whole nightmare can be over. Sounds tempting. It's quick cash and you need it. But this is the exact moment the alarm bells in your head should be screaming. This is the moment you lawyer up. Personal injury is one of the most misunderstood areas of law for the average American. We're bombarded with cheesy lawyer commercials and billboard ads. And it creates this perception that it's all about chasing an easy payday. But the reality is, the personal injury system exists because insurance companies are not your friend. Their entire business model is built on a simple principle. Take in as much money as possible in premiums and pay out as little as possible in claims. The adjuster's job is not to ensure you're made whole. It's to save their company money by getting you to accept the lowest possible offer. When you say, "I'm fine" at the scene, they document it. When you give them a recorded statement without a lawyer, they will ask leading questions designed to get you to downplay your injuries or accidentally accept partial blame. You said you were a little tired that morning, correct? Were you in a hurry to get to work? They will use your own words to build a case against you. They will offer you a quick settlement before the full extent of your injuries is even known. Because they know that once you sign that release, you can never go back for more, even if you discover 2 years later that you need a spinal fusion because of that minor fender bender. Hiring a personal injury attorney flips the script. Suddenly, the insurance company isn't dealing with an inexperienced, injured victim. They're dealing with a professional who knows their tactics inside and out. The lawyer's first instruction will be simple. Stop talking to the insurance company. From now on, they talk to me. This immediately shields you from their pressure tactics. Your lawyer will then manage the entire process. Gathering police reports, interviewing witnesses, collecting all your medical records, and working with your doctors to understand the long-term prognosis of your injuries. They understand what a case is truly worth. It's not just the immediate medical bills. It's future medical care. It's lost wages from the time you couldn't work. It's your loss of future earning capacity if you can no longer do your job. It's the non-economic damages, the real human cost. Your pain and suffering. These are things an insurance adjuster will never willingly offer you. A good lawyer builds a comprehensive case that demonstrates the full impact the accident has had on your life, and they will negotiate from a position of strength. And here's the most important part for most people. You almost never pay them a dime out of your own pocket. Personal injury lawyers work on a contingency fee. They take a percentage of the final settlement or verdict. If they don't win you any money, they don't get paid. This means they are financially invested in getting you the best possible outcome. Their interests are aligned with yours. The trigger for lawyering up isn't the accident itself. It's the injury. If you are hurt in any way, whether it's a car wreck, a slip and fall in a grocery store, or even a dog bite, you need to at least consult with an attorney. Let's take the slip and fall. You're walking down an aisle at a big box store, and you don't see a puddle of clear liquid that's leaked from a broken jar. Your feet go out from under you and you land hard, fracturing your wrist. The store manager rushes over, helps you up, and has you fill out an incident report. This is another critical moment. What you write on that report and what you do next matters immensely. The store has a legal duty to keep its premises reasonably safe for customers. The puddle of liquid created a dangerous condition. The central question in a premises liability case like this is, did the store know, or should they have known about the hazard, and did they fail to take reasonable steps to fix it or warn you about it? Was the spill fresh, or had it been sitting there for an hour while employees walked past it? Was there a wet floor sign? These are questions you are not equipped to investigate on your own. A lawyer will immediately send a spoliation letter to the store, a legal demand that they preserve all evidence related to your fall. This includes any video surveillance footage, employee logs, sweep sheets, and the incident report you filled out. Without this, that crucial video of the spill sitting on the floor for 45 minutes might just get accidentally erased. They will handle the store's insurance company, which will try the same tactics, blaming you for not watching where you were going, for wearing the wrong shoes, anything to shift responsibility. The same principle applies to an even more devastating category: medical malpractice. This isn't about a bad outcome. Medicine is complex and not every procedure is successful. Malpractice occurs when a healthcare provider, a doctor, a nurse, a hospital deviates from the accepted standard of care, and that deviation directly causes you harm. It's a surgeon who operates on the wrong limb. It's an anesthesiologist who administers the wrong dose. It's a doctor who looks at a clear-as-day tumor on an X-ray and dismisses it as nothing, leading to a delayed cancer diagnosis that becomes terminal. These are cases that are virtually impossible for a layperson to win on their own. The medical establishment and their insurance carriers are formidable opponents. They will close ranks, and records will be defended with an army of lawyers. To even bring a malpractice suit, you need another medical expert in the same field to review your case and testify that your doctor was, in fact, negligent. A specialized medical malpractice attorney has a network of these experts. They know how to read complex medical charts, they know what to look for, and they have the resources to finance a case that can take years and cost hundreds of thousands of dollars to bring to trial. If you even suspect that a medical error has caused serious harm to you or a loved one, a consultation with a lawyer isn't just a good idea. It is the only way to find out if you have a case. In all of these scenarios, the car crash, the slip, the medical error, the stakes are your physical and financial well-being. The other side has a team of professionals working to protect their bottom line. Lawyering up is not about being greedy or litigious. It's about leveling the playing field. It's about ensuring that your voice is heard, and that you have a professional advocate fighting to make sure you get the resources you need to put your life back together. Protecting your body and your health is paramount. But what about the very place you call home? What happens when a dispute over property lines turns your friendly neighbor into a bitter rival? Or the contractor you hired to build your dream kitchen vanishes with your money, leaving a trail of destruction behind? The fight then moves from the emergency room to your own front yard. Let's talk about the American dream's most sacred ground, your property. That little patch of earth you call your own. It's supposed to be your fortress of solitude, your sanctuary. But the brutal truth is that your biggest legal battles will often be fought over the very soil beneath your feet. Imagine this. You live in a quiet suburban neighborhood. You're friendly with your neighbor, Mark. You borrow tools, you wave when you get the mail, you complain about the homeowners association together. It's a perfectly normal, peaceful coexistence. Then one day, Mark decides to build a new fence. A beautiful 6-foot-tall cedar privacy fence. You're happy for him. More privacy, great. But as the posts go in, you get a weird feeling. It looks close. A little too close to your prize-winning rose bushes. You pull out the survey you got when you bought the house. You measure, and your stomach drops. The fence isn't on the property line. It's a full foot onto your land. A foot might not sound like much, but it's a foot of your land, along the entire 100-foot length of your property. That's 100 square feet. An entire walk-in closet's worth of your property, now on his side of a permanent barrier. So you do what any reasonable person would do. You walk over, survey in hand, and politely point it out. Hey Mark, I think there might be a small mistake with the fence line. And this is the moment where your reality splits into two different timelines. In one timeline, Mark says, "Oh wow, you're right. My mistake. Let's fix it." And you both have a beer afterwards. But in the timeline we're talking about today, Mark scoffs. He says, "The surveyor must be wrong. This is where the old fence was. It's fine." You insist. He gets defensive. The conversation gets heated. Suddenly, you're not neighbors anymore. You're adversaries. You send him a polite letter, including a copy of the survey. He ignores it. The fence is completed. Now, every time you look out your window, you see that fence, a wooden monument to his stubbornness, sitting on your land. Is it time to lawyer up? Over a foot of land? Most people would say no. Feels petty. It feels unneighborly. You'd be wrong. Dead wrong. This is a classic textbook example of when you absolutely need a lawyer, and you need one fast. Because this isn't about 1 foot of lawn. It's about a legal principle called adverse possession. In many states, if you allow someone to openly use your property for a certain number of years without contesting it, they can legally claim it as their own. That's right. Mark could eventually go to court and have your property line legally redrawn, and that 1 foot of land would belong to him forever. You would lose it. For good. All because you wanted to be the nice guy. When you hire a lawyer in this situation, you're not declaring war. You're establishing a formal record. The lawyer will send a certified letter, a demand letter that can't be ignored. It says, "We have a survey. Your fence is encroaching on my client's property. You have 30 days to remove it, or we will file a suit to quiet title and ask the court to order its removal at your expense. Suddenly, Mark isn't arguing with you, his neighbor. He's arguing with the law. And the law is backed by surveyors, deeds, and centuries of property rights. That fence will come down one way or another. You lawyer up not to start a fight, but to end one with facts before it escalates into a multi-year property value-destroying feud. But the threat isn't always from the other side of the fence. Sometimes the most dangerous person is the one you invite right through your front door. Let's talk about contractors. You and your spouse have been saving for a decade to finally get that dream kitchen. You find a guy, let's call him Mike, who seems perfect. He's got a slick website with a gallery of beautiful kitchens. He's charming, confident, and his quote is 20% less than everyone else's. Feels like you've hit the jackpot. Mike tells you he needs a 50% deposit up front to order the custom cabinets and secure the materials. It's a lot of money, say $40,000, but he explains that with supply chain issues he has to pay his suppliers in full right away. It makes sense. So you write the check. The first week is a whirlwind. Demolition. The old kitchen is gone in a cloud of plaster dust. You're excited. Progress. The next week, a plumber comes for a day and caps off some pipes. Then nothing. A week goes by. You call Mike. Oh yeah, he says. We're just waiting on the permit from the city. It's all bureaucracy, you know how it is. Another week. You text him. He replies 2 days later. My cabinet guy has COVID, everything's on hold. Another week. Now his phone goes straight to voicemail. His website is down. The $40,000 is gone. And your home, your sanctuary, is a chaotic, unlivable construction site with exposed wiring and a hole in the wall. This is a gut-wrenching, violating experience. And your first instinct is panic. Your second is to call the police. But the police will likely tell you this is a civil matter, not a criminal one. They can't force him to finish the job or give you your money back. This is the exact moment you stop being a victim and start being a plaintiff. You need a lawyer, and you need one yesterday. Why? Because this isn't just about getting your money back. It's about protecting yourself from things getting even worse. A good lawyer who specializes in construction fraud will immediately do several things. First, they'll file a breach of contract lawsuit. That contract you signed isn't just an agreement. It's a weapon. Your lawyer will use it to sue not only for the $40,000 you lost, but for the cost to hire a new, more expensive contractor to fix the mess and finish the job. But here's where it gets truly terrifying, and why a lawyer is non-negotiable. What if Mike, the charming contractor, took your $40,000 and never paid the cabinet company he supposedly ordered from? Well, that cabinet company can now place something called a mechanic's lien on your house. Let me repeat that. A company you've never even spoken to can put a legal claim on your property, saying you owe them money for materials for your project. If you don't pay them, they can sue you and potentially force the sale of your home to satisfy the debt. You could end up paying twice for cabinets you never even received. A lawyer's job is to prevent this nightmare. They will immediately send notices to all potential suppliers and subcontractors, putting a stop to any potential liens. They will investigate Mike's company, find out if he's a registered LLC or just a shell corporation, and begin what's called asset discovery, to find out where your money went. Can he be forced to sell his truck? Does he own property? They hunt for the money. They also file complaints with the state contractor licensing board, which can revoke his license and issue fines, putting immense pressure on him to make things right. Without a lawyer, you're just an angry homeowner with a disconnected phone number. With a lawyer, you are a legitimate threat with the full power of the legal system behind you. You're moving to freeze his assets, ruin his professional reputation, and hold him accountable not just for the money he took, but for the chaos he created in your life. The fight for your home is one of the most personal battles you can face. But what happens when the threat isn't to your property, but to your paycheck, to your career? What happens when the person trying to ruin your life isn't a crooked contractor, but your own boss? The battlefield shifts from the front yard to the fluorescent lights of the office, and the rules of engagement change completely. Let's be brutally honest. For most Americans, the workplace is the single most unbalanced power dynamic they will ever experience. Your employer controls your income, your health insurance, your schedule, and in many ways your future. And they know it. This power imbalance is codified in a legal concept that gets thrown around a lot, but is almost always misunderstood: at-will employment. You've heard it before. Maybe you even heard it in your onboarding. This is an at-will state, which means we can fire you at any time for any reason. And most people hear that and think, wow, I have zero rights. I better keep my head down. That is exactly what your employer wants you to think. But it's a dangerous oversimplification. At-will employment doesn't mean you can be fired for any reason. It means you can be fired for no reason. But you absolutely 100% cannot be fired for an illegal reason. And the gap between no reason and an illegal reason is where your rights live. And it's where an employment lawyer becomes your most powerful ally. Let's start with the big one, wrongful termination. This isn't about getting fired because your boss didn't like your attitude, or because you were 5 minutes late one too many times. That's getting fired for a bad reason, but it's not illegal. Wrongful termination is when you're fired for a reason that violates federal or state law. The most common illegal reason is discrimination. Federal law protects you from being fired based on your race, color, religion, sex, national origin, age, or disability. Many states add more protections, like sexual orientation or marital status. But here's the problem. No company is stupid enough to put the illegal reason in writing. You're never going to get an email that says, "We're letting you go because you're turning 55, and we want to hire someone younger." Companies are experts at creating a pretext, a fake but legal-sounding reason for your termination. They'll suddenly create a paper trail. They'll say your performance suddenly declined after years of great reviews. They'll say your position was eliminated in a restructuring, only to hire someone else for the exact same job a month later. Imagine this. You're a top salesperson, let's call you David. For a decade, you've hit every target, won every award. You're 58 years old. A new younger manager comes in. He starts making comments in meetings about needing new blood and bringing a more youthful energy to the team. Suddenly, your sales territory gets cut. Your best accounts are given to the new 25-year-old hire. Your new sales quotas are mathematically impossible to hit. For the first time in your career, you're put on a performance improvement plan, a PIP. You know what a PIP really is? It's not a plan to improve your performance. It's a plan to document your exit. 3 months later, you're fired for failing to meet performance expectations. You feel it in your gut. You know you were pushed out because of your age. But what can you do? This is the moment to lawyer up. An employment lawyer knows how to cut through the company's pretext. They'll look for the pattern. Are other older employees being pushed out? Were the comments about youthful energy heard by witnesses? How does your performance, even on the PIP, compare to the younger employees who weren't fired? The company has a team of lawyers and an HR department dedicated to making this look legal. A lawyer is the only person who can level that playing field for you. The second huge category of wrongful termination is retaliation. This is when the company punishes you for doing something you have a legal right to do. Did you report sexual harassment? Did you file for workers' comp after getting injured on the job? Did you report the company for breaking a law, an act known as whistleblowing? Or did you simply ask a question about why you aren't being paid overtime? If you do any of these things and are suddenly fired, demoted, or have your hours cut, that's a massive red flag for retaliation. Let's take another example. Sarah, an accountant, discovers her company is engaging in some very creative and likely illegal bookkeeping to mislead investors. It makes her deeply uncomfortable. She follows the company's own policy and reports her concerns to her direct supervisor. Her supervisor tells her to mind her own business. A week later, Sarah is called into an HR meeting. They claim 3 anonymous colleagues have suddenly complained about her negative attitude. She's never had a complaint in her life. She's written up. Her projects are reassigned. Her access to certain financial systems is revoked. 2 months later, they fire her for not being a team player. This is a classic retaliation playbook. They couldn't fire her for reporting the fraud, because that's illegal whistleblowing. So they invented a pretext. They built a fake case against her. For Sarah, a lawyer isn't just a good idea. It's a necessity. A lawyer can use legal tools like discovery to demand emails, internal memos, and depositions from the company. They can uncover the truth that Sarah's attitude problem only magically appeared after she did the right thing. Without a lawyer, it's just your word against a multi-million-dollar corporation. Beyond getting fired, there's the soul-crushing experience of a hostile work environment. This is another term that's widely misunderstood. A hostile work environment is not just having a boss who's a jerk. It's not high pressure or a stressful job. Legally, a hostile work environment is created when you face harassment that is so severe or pervasive that it alters the conditions of your employment, and creates an abusive working environment. And crucially, that harassment must be based on your membership in a protected class, your race, gender, religion, and so on. A single off-color joke probably doesn't count. But constant, daily jokes about your gender? A supervisor who only gives demeaning tasks to employees of a certain race? A workplace where racial slurs or sexually explicit images are common? That's when you cross the line. The key is to document everything. Every single incident. The date, the time, what was said, who was there. And you must report it. You have to give your company a chance to fix it. Send an email to HR. Create a paper trail. If they do nothing, or if the harassment gets worse after you report it, which is retaliation, that is the exact moment you pick up the phone and call an employment lawyer. Finally, we have the quietest but most common way employers break the law: wage and hour violations. This is straight-up theft. They're stealing your money. Are you being forced to work off the clock? Answering emails and texts from your boss at 10 p.m.? That's work, and you must be paid for it. Are you being paid a salary and told you're exempt from overtime, but you're working 60 hours a week doing the same job as the hourly employees? You might be misclassified. Companies save millions by misclassifying employees as salaried exempt or as independent contractors to avoid paying overtime, and it is rampant. A lawyer specializing in this can look at your actual job duties, not just your title, and determine if you're owed thousands or even tens of thousands in back pay. In all of these situations, there's one critical, non-negotiable rule you must burn into your brain. Human resources is not your friend. HR's primary legal and ethical duty is to protect the company. Their job is to mitigate the company's risk and liability. While many HR professionals are good people, the department's function is not to be your advocate. It is to be the company's first line of defense. When you go to HR with a serious complaint, their first thought isn't, "How do we help this employee?" It's, "How do we make sure the company doesn't get sued?" They will document everything you say to build a case for the company, not for you. So by all means, follow company policy and report issues through the proper channels. But do it in writing, be careful what you say. And if the situation involves illegal activity, consult with a lawyer before you walk into that HR office. Your job is your livelihood. It's how you feed your family and build your future. And when that's threatened by illegal actions, you cannot afford to fight alone. You're being asked to sign a severance agreement? Don't sign it until a lawyer reviews it. You're put on a PIP right after reporting harassment? Call a lawyer. You're fired and you just know it's because of your age, your gender, or because you spoke up. Call a lawyer. The initial consultation is almost always free. You have nothing to lose by getting an expert opinion, and you have everything to lose by staying silent. The stress of a toxic job or a wrongful termination can tear your professional life apart. But what happens when the conflict isn't with your boss, but with the person you promised to spend your life with? The stakes become even higher, the issues more personal, and the need for a legal shield becomes painfully, immediately clear. The vows say, "Till death do us part." But the harsh reality for nearly half of American marriages is, "Till the lawyers do us part." And nothing, absolutely nothing, feels more like a personal failure than the unraveling of a family. It's a storm of grief, anger, and confusion. In the middle of that emotional hurricane, the last thing you want to think about is legal strategy. You just want it to be over. You might tell yourself, "We can be adults about this. We can do this amicably. We don't need to get lawyers involved and make it ugly." And that single thought, born from a desire for peace, can be the most financially and emotionally devastating mistake of your life. The concept of an amicable, do-it-yourself divorce is one of the great modern myths. It's a beautiful idea, but it's built on a faulty premise. It assumes that two people at the most stressful point in their lives can untangle years, sometimes decades, of shared finances, assets, debts, and parental responsibilities with perfect fairness and foresight, all while navigating a complex legal system they don't understand. It's like trying to perform surgery on yourself using a YouTube tutorial. You might get lucky, but the odds of catastrophic error are terrifyingly high. Let's talk about what a divorce actually is. It's not just signing a paper that says you're not married anymore. It is the legal dissolution of a complex financial partnership. Every dollar you earned, every dollar of debt you incurred during that marriage, is likely considered marital property. That 401k your husband has through his job, the one with only his name on it, you're likely entitled to half of the value that accrued during the marriage. That credit card debt your wife racked up on a card you didn't even know she had, you might be on the hook for half of it. The house? It's not as simple as one person getting it. Who will pay the mortgage? Who is responsible for taxes and repairs? How do you get the other person's name off the deed and the loan? If you sell it, how are the proceeds divided after costs? Without a lawyer, you are guessing. You are making decisions that will impact your financial security for the rest of your life based on assumptions, emotions, and what you think is fair. But the law has a very specific definition of what's fair, and it's called equitable distribution. And it's almost certainly not what you think it is. Consider a story, a scenario that plays out in law offices across the country every single day. Let's call them David and Sarah. They've been married for 18 years. David is a successful contractor, and Sarah left her nursing career 15 years ago to raise their 3 children. The split is sad, but they agree no lawyers. They want to save the money and protect the kids from a nasty fight. They sit at the kitchen table, the same table where they share thousands of meals, and try to divide their life. David says, "You can have the house. I want you and the kids to be stable. I'll just keep my business and my retirement account." To Sarah, this sounds incredibly generous. She gets the family home, the place her kids grew up. Feels safe. Feels fair. She agrees. They download the forms, check the boxes, and sign. They feel proud of themselves for handling it with such maturity. Fast forward 2 years. The roof on the house needs to be replaced. A $20,000 expense Sarah has no way to pay. The property taxes have gone up, and the part-time job she found as a receptionist doesn't even cover the bills. She's drowning in a house she can't afford. Meanwhile, David's contracting business, which they started together with money from their wedding, has exploded in value. The retirement account she signed away is now worth over $1 million. She signed away her legal right to a share of the business and the retirement funds, marital assets worth hundreds of thousands of dollars, in exchange for a house that has become a financial anchor around her neck. She didn't get alimony because she didn't ask for it, not knowing she was likely entitled to it to help her get back on her feet and retrain for a new career. The fair deal she made at the kitchen table has sentenced her to a future of financial struggle, while her ex-husband's future is more secure than ever. This isn't a story about a bad person. David wasn't trying to be malicious. He probably thought he was being fair, too. This is a story about a lack of information. Sarah didn't know her rights. She didn't have an advocate, an expert whose sole job was to look at the situation objectively and advise her on the long-term consequences of her decisions. A 1-hour consultation with a lawyer would have changed the entire trajectory of her life. A lawyer would have explained that the business and the retirement were marital assets. They would have arranged for a forensic accountant to value the business properly. They would have drafted a special order, called a QDRO, to transfer her share of the retirement funds into her own account without tax penalties. They would have negotiated for alimony, giving her the breathing room to go back to school and restart her nursing career. They would have shown her that keeping the house might not be the best financial move, and that selling it and splitting the proceeds might provide her with the capital she needed for a truly fresh start. The lawyer's job isn't to start a war. It's to prevent you from unknowingly surrendering. And this is all before we even mention the most important thing, the children. When kids are involved, the stakes are infinitely higher, and trying to handle custody without a lawyer is one of the riskiest gambles a parent can take. You might say, "We'll just do what's best for the kids. We'll split time 50-50. But what does that mean in practice? Which 50%? Who has them on Christmas morning? On their birthday? Who makes the final call if you disagree on whether your child should get braces or play tackle football? What happens if one of you wants to move to another city for a new job or a new partner? A handshake deal on custody is worth less than the air it's spoken into. It is completely unenforceable. If your ex decides one day to not bring the kids back after their weekend, and you don't have a formal court-ordered parenting plan, your recourse is frighteningly limited. A lawyer helps you build a comprehensive parenting plan that is filed with the court and becomes law. It is a detailed rulebook for your co-parenting relationship. It covers schedules, holidays, vacations, decision-making authority for education and healthcare, rules about travel, and how future disputes will be resolved. It provides predictability and stability for your children in a time of chaos. And most importantly, it provides a legal, enforceable document that protects your fundamental right to be a parent to your child. It is the ultimate shield. So when is it an absolute, non-negotiable, drop everything and call a lawyer moment? First, if there is a power imbalance of any kind. If one spouse has always controlled the finances, if there's a significant income disparity, Or if there's a history of control or intimidation, you need an advocate. The person who holds the power is not going to voluntarily cede it fairly. Second, if you suspect your spouse is hiding assets. If they're suddenly secretive about finances, if large sums of money are moving out of joint accounts, if new accounts are being opened, these are massive red flags. A lawyer has tools you don't, like the power of discovery, to subpoena bank records, credit card statements, and business ledgers to find that money and ensure it's part of the negotiation. Third, and this is the most critical, if there is any history of domestic abuse, be it physical, emotional, or financial, this is no longer just a divorce. It's a safety and extraction plan. A lawyer is your essential partner in securing restraining orders, establishing safe custody exchanges, and using the full power of the court to protect you and your children. Do not attempt to navigate this alone. And finally, the simplest rule of all. If your spouse has a lawyer, you need a lawyer. Period. Full stop. End of story. Showing up to divorce proceedings without a lawyer when your spouse has one is like willingly walking into an ambush. Their lawyer is not your friend. They are not a neutral mediator. Their one and only ethical duty is to get the absolute best outcome for their client, which is often at your direct expense. You must have someone in your corner with the same level of expertise and the same singular focus on protecting your interests. Getting a divorce lawyer isn't an act of aggression. It's an act of self-preservation. It's about ensuring that the next chapter of your life starts on a foundation of fairness and security, not on the ruins of regret. It's about protecting your future. And if you have kids, it's about building a legal fortress around your relationship with them. While the emotional ties may be breaking, the legal and financial ones must be severed with precision and care. Because failing to do so can create a whole new kind of prison long after the marriage is over. But sometimes the threat isn't the slow dissolution of a partnership, but the sudden terrifying clang of a jail cell door. That sound, whether real or imagined, signals the single most critical moment you will ever need a lawyer. We're talking about criminal charges. This is the government with its immense resources, its police forces, its prosecutors, and its prisons, deciding to point its full power directly at you. In this arena, trying to represent yourself isn't just a bad idea. It's an act of self-destruction. Let's start with the moment it happens. The flashing lights in your rearview mirror. The knock on the door in the middle of the night. The two detectives who approach you on the street. Your adrenaline spikes. Your mind races. Your first instinct, your most human instinct, is to explain, to cooperate, to clear up this misunderstanding. This instinct is a trap. It is the single biggest mistake you can make. When an officer puts you in handcuffs and reads you your rights, the most famous words are, "You have the right to remain silent." But the most important words are the ones that come next. Anything you say can and will be used against you. Believe them. Police are not there to hear your side of the story. They are not mediators. They are not your friends. They are investigators trained in interrogation techniques designed for one purpose: to get you to talk, to get a confession, or, at the very least, to get you to say anything that contradicts another piece of evidence. Imagine you're arrested for a robbery that happened on Tuesday night. You're innocent. You were at home alone watching a movie. The police ask you where you were. You say, "I was at home." A week later, they ask you again. This time, flustered, you say, "I think I was watching TV." To you, it's the same thing. To a prosecutor, it's an inconsistency. It's a crack in your story. Suddenly, you sound like a liar. You tried to help, and all you did was help them build a case against you. There are only two sentences you should ever say to the police after being arrested. Memorize them. Burn them into your brain. First, "I am going to remain silent." Say it clearly and calmly. And second, "I want a lawyer." After you say those two things, you stop talking. Completely. It doesn't matter what they say. They might tell you that you're making things worse for yourself. They might say that if you're innocent, you have nothing to hide. They might say your friend in the other room is already talking and blaming you. These are tactics. Your silence is not an admission of guilt. It is an assertion of your constitutional rights. It is a shield. And your lawyer is the one who will wield it for you. But what if you haven't been arrested? What if detectives just call you and say they want to talk? This is an even more dangerous situation because your guard is down. You don't feel like a suspect. You feel like a citizen helping with an inquiry. You might think, "If I don't talk, they'll think I'm guilty." Let me be clear. They already suspect you might be. That's why they're calling. They are not trying to clear your name. They are trying to build their case. You are under no legal obligation to speak with them without an attorney present. The correct and only response is, "I will cooperate fully, but I will only do so with my lawyer present." This isn't suspicious. It's intelligent. It signals that you understand your rights and you take the situation seriously. Let's take one of the most common criminal scenarios in America. A DUI. You're driving home after 2 beers with dinner. You get pulled over for a broken taillight. The officer smells alcohol on your breath and asks you to step out of the car. He asks you to perform a field sobriety test, walk a straight line, touch your nose. These tests are notoriously subjective. They are designed to be difficult even for a sober person under the stress of a police stop on the side of a dark road. In most states, you can politely refuse to take a field sobriety test. Then comes the breathalyzer. This is different. Under what are called implied consent laws, by driving on a public road, you have already agreed to submit to a chemical test if lawfully arrested for a DUI. Refusing the breathalyzer often carries its own severe, automatic penalties, like a 1-year license suspension, regardless of whether you're ultimately found guilty of the DUI. It's a legal minefield. Do you take the test and risk giving them the exact evidence they need to convict you? Or do you refuse and face automatic consequences? This is precisely where a lawyer becomes indispensable. A good DUI attorney knows the law inside and out. They can challenge the legality of the initial traffic stop. If the cop had no valid reason to pull you over, everything that follows can be thrown out. They can challenge the calibration records of the breathalyzer machine. They can scrutinize the officer's procedure and report for any errors. You see a conviction, they see a dozen potential points of defense. Without a lawyer, you are accepting the state's version of events as gospel. With a lawyer, you are forcing the state to prove its case beyond a reasonable doubt every step of the way. The difference can be your freedom, your job, and your future. And so we come to the end of our journey. We've walked through the biggest moments in an American life. Buying a home, the foundation of your future. Starting a business, the pursuit of your dream. Writing a will, the shape of your legacy. Getting injured, a moment of sudden vulnerability. Getting divorced, the painful restructuring of a family. And finally, facing the terrifying power of the state in a criminal case. What is the one thread that connects all of these disparate events? They are all inflection points. They are moments of profound consequence, where the path you choose can echo for decades. And in every single one of these moments, the American system of laws and contracts and procedures is not a gentle guide. It's a complex, often brutal, game with hidden rules and serious penalties. A lawyer is not a luxury for the rich or a tool for the guilty. A lawyer is a professional guide for navigating the most difficult terrain of your life. They are your translator in a foreign language of statutes and case law. They are your advocate when you cannot speak for yourself. They are your shield when you are under attack. The American legal system is, by its very design, adversarial. It assumes that the truth will emerge from a battle between two opposing sides, each armed with the best arguments and evidence they can find. Showing up to that battle alone, whether it's against a massive insurance company, a contentious spouse, or a state prosecutor, is not a noble act of self-reliance. It is an act of unilateral disarmament. It is like stepping into a boxing ring to face a heavyweight champion with one hand tied behind your back. You may be in the right, you may have truth on your side, but you are almost certainly going to lose. Understanding when you need to lawyer up isn't about being paranoid. It's not about looking for a fight. It's about recognizing the gravity of a situation. It's about respecting the complexity of the system we all live in. It's about giving yourself a fighting chance when the stakes are highest. Because in the moments that truly define your life, the cost of a good lawyer is never, ever as high as the cost of not having one.